This comes out of a paper I'm still working on. It started out as a sort of it's left its origins behind, but it started out as a kind of meditation on Charles Reich's New Property, which was published, it'll be 50 years ago next year. And this is really, it's a landmark article in which Reich meditates on the rise of what he calls the public interest state with its vast resources and unbridled discretionary authority over the largesse it distributes. And really hard to overstate its influence. I mean, it's been cited thousands of times, one of the most cited law review articles ever in numerous Supreme Court opinions, more recently in, not really since the 70s in Supreme Court opinions, and mostly in dissents after Goldberg versus Kelly, but it's still, you know, when your work is quoted, you know, by the Supreme Court, that's sort of the most law professors can aspire to, I think. So by that measure, the article is a kind of giant in the 20th century canon. And today it's most often remembered for its call to treat welfare benefits as property. Sort of the new property refers to this largesse, and Reich's call to give public largesse the status of private ownership. But the article's also notable, I think, as a property professor. What I found when I went back and reread it, it's notable for its very stark description of property rights in strongly libertarian terms as a bulwark for the individual against state power and majority sentiment. So the very first line of the article, Reich says, "The institution called property guards the troubled boundary between the individual man and the state." The 50 years since the new property was written, I think, has witnessed the rise of a sophisticated property rights movement that didn't exist at the time that Reich was writing, that's aimed at protecting and expanding the prerogatives of private ownership against encroachment by the public interest state that Reich feared. And this period's also kind of ironically coincided with a collective turning away, I guess, from the kinds of social welfare programs that Reich wanted to convert into entitlements in order to better secure individual autonomy. But what's interesting is that strikingly absent from the article, Reich's article, just as it is in contemporary discussions of property rights in the United States, is the potential or a kind of adequate recognition of the potential for private forces, private parties to undermine property rights, and the vital role of the state as a defender of private property. So who do owners turn to when they're fighting off violations of their property rights by other private actors? One place they don't turn is to property rights litigation groups. The Institute for Justice, which has a clinic at the University of Chicago, is a leading property rights litigation group. It was founded with seed money by the Koch brothers, or Koch brothers, whatever. It says that it doesn't get involved in disputes between private parties. It describes its mission as protecting, and I'll quote here from their website mission statement, individuals whose most basic rights are denied by the government. Simply put, the website declares, "We challenge the government when it unconstitutionally takes away individuals' property." So there's this kind of libertarian inattention to private disputes over private property, or we can call private violations of property rights. And it's an interesting phenomenon, I think, that calls out for a little consideration, a little prolonged consideration, because at least for non-anarchist libertarians, so people like Robert Nozick, and I'll throw Ayn Rand in there, even though I hesitate to put them in the same sentence, private disputes over property really lie at the center of their political philosophy, right? I mean, it's a sort of starting point for Nozick is the creation of a state that's justified only when it limits itself to protecting all its citizens against violence, theft, and fraud, and to the enforcement of contracts. Even if the means by which it funds these what we'll call property protective activities is redistributive in some sense. So Nozick's opposed to redistribution generally, but he's okay with the redistributive consequences of the state provision of this protective activity. And this echoes Locke's assertion that the great and chief end of men's uniting into commonwealths and putting themselves under government is the preservation of their property. So for these kinds of statists, I'm not going to call Locke a libertarian, although he is sort of the inspiration for contemporary libertarian property thought, but for statist libertarians in the 20th century, the private threat to property is prior to the public threat, and the danger that democratic governments pose to property rights arises only because of the need to institute those governments so as to combat the potential for private abuse in their state of nature. And so what I'd like to do today is briefly explore the implications of private violations of property rights for what I'm going to call broadly libertarian accounts of property, like Nozick's and like the one that Reich embraced in the New Property. And this is, again, I'm going to try to take them, at least reconcile some tensions within Reich's New Property and take Nozick in directions that he doesn't want to go. So what I'll argue is that the libertarian notion of a state whose purpose is the protection of property suggests an obligation by that state to provide meaningful access to the mechanisms for the protection of property, and these include not just criminal law enforcement, which is sort of Nozick's focus, but also civil law enforcement. And then in addition, and arising out of this obligation, I'll argue that it's not an enormous leap to assert an even broader obligation by the libertarian state to curb excessive economic inequality. But before making those arguments, I think it's helpful to understand how property rights discourse has developed to its present condition, in which property is treated primarily as a bulwark against state intrusion, with the state seen as the threat and not the defender of property. And the sole focus of attention is on the restraint of the state rather than the empowerment of the state to actually protect ownership. So, as many have observed, throughout American history, the property thought of John Locke has consistently played a dominant role in shaping the rhetoric in which property rights are discussed. And despite this, or maybe because of it, the invocation of the language of property rights was, until the 20th century, characterized by a great deal of ideological diversity. So embodying this polyvalence of Locke's property thought at the turn of the 19th century, I think, is Thomas Paine. On the one hand, Paine was an eloquent critic of government overreach and an ardent advocate of natural property rights and free markets, but on the other, he was the earliest advocate of something like the modern welfare state in the United States. And both of these positions were rooted in his specifically Lockean understanding of property. So in his 1795 pamphlet, Agrarian Justice, Paine deployed strongly Lockean property concepts in support of his proposals to create a national fund, I'm quoting from the pamphlet now, out of which there shall be paid to every person when arrived at the age of 21 years the sum of 15 pounds sterling as a compensation in part for the loss of her natural inheritance by the introduction of a system of landed property. And that's the end of the quote. And then Paine planned to pay for this fund by means of a very steep estate tax. Although he shared the Lockean intuition that most of the value in improved land was the product of human labor and therefore properly the object of individual ownership, he believed that there remained in all property a residual common interest that could not be extinguished. And maybe this relates up to the Linebaugh reading a little bit. But so I'll quote from Agrarian Justice. He says, "As it is impossible to separate the improvement made by cultivation from the earth itself upon which that improvement is made, the idea of landed property arose from that parable connection. But it is nevertheless true that it is the value of the improvement only and not the earth itself that is individual property. Every proprietor, therefore, of cultivated lands owes to the community a ground rent, for I know of no better term to express the idea, for the land which he holds, and it is from this ground rent that the fund proposed in this plan is to issue." For Paine, the common interest in private fortunes extended even to property other than land, since he thought wealth in general was dependent on social preconditions for which individuals could not properly claim credit. Wealth generated from participation in market transactions, for example, is always dependent upon work in cooperation with others, and economic value itself is generated and requires both supply and demand. And so even in the simplest act of buying and selling, we see a kind of successful collaboration between parties. And consequently, Paine argues, owners of non-landed wealth could not claim to be the sole origins of their own fortunes. As a result, this wealth as well was subject to a kind of social servitude, we'll call it. To quote again from Agrarian Justice, he says, "Separate an individual from society and give him an island or a continent to possess, and he cannot acquire personal property. He cannot be rich. So inseparably are the means connected with the end in all cases, that where the former do not exist, the latter cannot be obtained. All accumulation, therefore, of personal property beyond what a man's own hands produce is derived to him by living in society, and he owes on every principle of justice or gratitude and of civilization a part of that accumulation back again to society from whence the whole came. Now, because Paine viewed his redistributive proposal in agrarian justice as rooted in a common human entitlement on which property rights are sort of engrafted, he was emphatic that it is a right and not a charity that I am pleading for. Over the course of the 19th century, property rights discourse existed in two broadly competing strains, reflecting, I think, the two halves of Paine's and Locke's property thought. The first built on Paine's advocacy of minimum welfare entitlements to generate a fairly radical critique of private ownership rooted in property inequality. And then the other strain embraced a version of the laissez-faire that viewed the existing distribution of property entitlements as radically constraining the legitimate scope of government action. But for all their differences, both of these schools of thought presented their arguments in terms of natural property rights. Now, in the 20th century, in the place of the rhetoric of property rights, progressives and legal realists turned to a conception of expert policymaking in which property became the end product of discussions conducted largely in other terms. And it was against this progressive approach to or disdain for the concept of property that Charles Reich was reacting, I think, when he wrote The New Property. Now, part of Reich's part of the explanation for Reich's focus on government, as Carantani has observed, was no doubt his personal experience with McCarthyism and its impact on government largesse in cases like Fleming versus Nestor. The failure of the progressive and realist architects of the welfare state to craft welfare state entitlements in terms of traditional property categories, I think, facilitated these abuses. And Reich was, he was kind of there. He was a Supreme Court clerk, I think, when Fleming versus Nestor was. So he saw these things firsthand and was very troubled by McCarthyism and its effect on individuals who were reliant on government largesse for their well-being. But an additional explanation probably comes from the fact that Reich was writing at the very low point of post-war economic inequality in the United States. Economic inequality was hovering at its lowest levels in the 1950s and 60s, right around the time Reich was penning The New Property. And most economic theorists at the time accepted Kuznets' hypothesis that low inequality was the new normal and a kind of permanent state for developed industrial economies. And so if that were true, the vast inequality of the Gilded Age was a kind of anomalous and transitory consequence of the shift from an agrarian to an industrial economy. And so concerns rooted in that experience may have seemed outmoded to Reich. Whatever his reasons, his orientation against state power and the humiliations it visited on vulnerable welfare recipients pushed Reich into the arms of the laissez-faire strain of property thought. And The New Property was therefore bedeviled by a kind of tension between Reich's progressive support for redistributive welfare state policies and his reliance on a conception of ownership that was narrowly associated with opponents of those policies. Property, on Reich's view, performs the function of maintaining independence, dignity, and pluralism in society by creating zones within which the majority has to yield to the owner, he says. In his view, the principal threat to independence, dignity, and pluralism was the power of the welfare state over individuals. And so the bulk of The New Property was focused on exploring the dangers of this growing government power over the recipients of largesse for individual liberty and dignity. Caught in the vast network of regulation, Reich warned, the individual has no hiding place. And Reich's conception of property as a zone within which owners have unfettered freedom and the government as the principal threat to that freedom fits very comfortably, obviously, with this laissez-faire property tradition. But many commentators have thought that his reliance on that tradition's account of property generated a number of problems for him. William Simon has a nice piece to that effect. I'll argue that this tension, though real, is somewhat overstated, and that a fuller libertarian account of property would help Reich to tie the two halves of the argument together. So one difficulty commentators have observed is that treating property rights as a bulwark against majoritarian politics, as Reich did, prevents the government from gathering the resources necessary to convert welfare benefits into property-like entitlements. And then a second problem is that the resulting tendency for Reich in the article to downplay the significance of private threats to private property and to the individual autonomy that property, in his view, safeguards. Almost totally absent from the new property are those whose vulnerability is not primarily to the state. So, for example, members of the working poor, those who are employed and therefore dependent on others, their employers for their well-being, but who are not particularly dependent on the government for their livelihoods. Reich occasionally acknowledges that large property owners could overwhelm even the government, subverting public power to private ends. And although he recognized that from an individual's point of view, it is not any particular kind of power, but all kinds of power that are to be feared, he had little to say about the need to rein in the private power of the farm landowner, the city landlord, or the working man's boss, as he put it, all of whom he recognized as capable of using their property rights, and then in his language again, to oppress their tenants and employees. So the problem with Reich's embrace of the laissez-faire, according to this commentary on the new property, is that while it provides reasons for protecting welfare recipients against the state, it doesn't offer any reason for the state to create welfare in the first place. And faced with increasing state power engendered by government largesse, the laissez-faire theory of property arguably fits better, or at least as well, with calls to shrink government's provision of largesse than with one to convert the largesse into property rights, or so the argument goes. So in thinking about the tensions within the new property, I think it's useful to bring Reich's insights into dialogue with his contemporary Adolf Berle. Or sort of, they overlapped anyway. Berle's a little older. But in his unfairly neglected essay, Property, Production, and Revolution, Berle observed that economically productive property that confers the sort of independence Reich was eager to defend, was increasingly at the time owned by large corporations, and concentrated ownership of the means of production, Berle thought, undermined individual independence and subjected the individual to new threats from powerful private actors. And the threat that concentrated private ownership posed individual freedom necessitated, in Berle's view, state regulatory efforts to protect individuals operating within the zone of corporate control. And I think Berle's and Reich's insights complement each other nicely. They sort of represent two wings of Paine's thought, and Locke's thought as well. So Locke and Berle kind of understood that the robust state is essential if small actors are to fend off private abuse. And Locke and Reich are also correct, or at least observed, that the state power itself constitutes an independent threat. And to think otherwise, Locke famously warned, is to take care to avoid what mischiefs may be done by polecats or foxes at the cost of being devoured by lions. Because a government powerful enough to accomplish the task of taking on private threats to individual rights is also capable of becoming an independent threat to freedom itself. But digging in a little deeper into the question of the relationship between property and individual freedom, we see that from the very first line of the article, Reich has the mechanism exactly backwards. Far from being an institution whose primary purpose is to guard the troubled boundary between the individual man and the state, property works, at least in the first instance, by empowering private individuals to call upon the government to protect them from other private actors, the people committing theft and fraud and violating contracts and things like that. So respect for private property is simply the means by which the state expresses its prior acceptance of some degree of individual freedom and the rule of law. And as the literature on informal property rights and social norms suggests, some private owners, I think, would no doubt be able to exercise their natural property rights even in the absence of an effective state with the power to coerce others to respect those rights. But others, most likely, or most people, are not strong enough or rich enough to protect their own entitlements against those who are intent on violating them. For these people, the absence of effective state power makes their moral property rights largely meaningless if they're unlucky enough to come across a strong bad actor. As moral entitlements, the property rights of even the weak and powerless within libertarian thought are understood to deserve recognition and protection, but because, as a practical matter, property rights are insecure against threats posed by other private parties in the absence of state authority, something like the minimal night watchman state is not merely justified, but arguably required from within this statist libertarian tradition. Now, this is contrary to what the Supreme Court has held our Constitution to mean as a matter of positive law in cases like DeShaney versus Winnebago County, Department of Social Services, and the Town of Castle Rock versus Gonzales. So I'll just read briefly from DeShaney. The court said DeShaney was a case involving a claim against a local government that failed to intervene to protect a child from child abuse, and then he was permanently kind of mentally damaged by the abuse, and that brought a lawsuit against the local government. And the court said, in rejecting the claim, the court said, nothing in the language of the Due Process Clause requires the state to protect life, liberty, and property of its citizens against invasion by private actors. The clause is phrased as a limitation on the state's power to act, not as a guarantee of certain minimum levels of security, safety and security. It forbids the state itself to deprive individuals of life, liberty, and property without due process of law, but its language cannot fairly be extended to impose an affirmative obligation on the state to ensure that those interests do not come to harm through other means. Not clear why there needs to be a state then, right? The Supreme Court's lopsided state constraining reading of the Constitution, I think, though, parallels Reich's fixation on constraining state power in the new property. Reich criticizes the power of that discretionary largesse confers on state actors without providing any real conceptual tools for justifying the state's involvement in the provision of largesse. And I think similarly, the court in Descheny reads the Constitution as preoccupied with limiting state power, but as having nothing to say with why government should exist in the first place. At a minimum, the necessary role of the state in enforcing property rights powerfully qualifies the kind of protection that property can be thought to grant owners against the state. And it's useful to contrast property's relative toothlessness against the state with the liberty protective functions of gun ownership, right, claimed by radical gun rights advocates. So according to Wayne LaPierre, the former head of the National Rifle Association, freedom is nothing but dust in the wind till it's guarded by the blue steel and dry powder of a free and armed people. Our founding fathers understood that the guys with the guns make the rules. Now, this scenario is obviously implausible, right? The idea of gun owners deterring tyranny by deploying the state-independent power of their munitions bears no resemblance, though, to the very law-dependent and therefore state-dependent mechanisms by which private property is supposed to protect, rather than merely embody, individual liberty against state encroachment, right? And Reich's problem is that he treated property as the equivalent of a loaded gun, but levied against a state that's inclined not to cooperate with property owners. A claim to property is really just no more than a plea for mercy. Reich's call to enhance the freedom of welfare recipients by treating welfare as property is really just a call for the state to stay its own hand. African American owners driven from their homes by white neighborhood associations in the mid-20th century and Native Americans trying in vain to hold off encroachments on tribal land by white settlers in the 19th century illustrate the empty promise of property rights without effective state backing. More directly on point, I think we can and more contemporary perhaps, we can take the example of undocumented immigrants who are perhaps more isolated from the mechanisms of law enforcement than any other group in contemporary society and cut off from the government's property protective functions. They become magnets for criminal violation of their property rights and other rights as well. And the consequence is an erosion of the security of their property. Now, when libertarians talk about the state's proper role in protecting owners from force and fraud, they're really describing the mechanism by which the state's enforcement of property rights empowers individuals against other private parties. And this enforcement has complicated consequences for individual freedom. On the one hand, as I've argued elsewhere, ownership reinforces social norms and particularly among equals engaged in property-mediated relationships, such as neighbors, it sort of constrains, right? Property ownership can actually constrain individual freedom, understood in kind of negative libertarian terms. And we can think of these social kind of property-propagated norms as horizontal informal constraints on individual freedom. Rather than liberating owners from the influence of others, property ownership actually strengthens these kinds of social forces. On the other hand, someone who owns economically productive property does genuinely seem less susceptible to the coercive power of the landlord and the employer, which depend for their force more on an assertion of formal property rights. The famous case of, New Jersey case of State versus Shack, I think, is a good example of these dynamics. And do people know that case, or have you talked about it? So State versus Shack was a case in which a farm owner had invited migrant laborers onto his property. They were his workers, and he provided housing for them on his property. And then when a state-funded legal aid lawyer and someone working for the local health department tried to come and visit the workers to provide services, he insisted on the ability to keep them off his land, right? To require these state service providers to provide the services in front of him, right, to the workers, and not to allow the workers to receive visitors of their own choosing. And you can see how the property there the property ownership, right, the assertion of the property ownership has the potential to create this kind of authority over the people existing within the property. And the state of New Jersey held that as a matter of property law, state property law, when you open your property up to outsiders like that, you lose the right to control who can come on and off your property to a certain degree. And as long as the workers were receiving visitors in a non-disruptive manner, they were entitled to receive those visitors of their choice on the farm owner's land. The power of property rights to protect owners against the kind of vertical private coercion that the farm owner in State versus Shack was attempting to assert is really largely absent from Reich's discussion of the new property. The close connections between welfare entitlements and the private power of employers over their workers forms the crux of Francis Fox Piven and Richard Cloward's classic theory of welfare benefits as tools for disciplining labor. The workhouse, they argue, was designed to spur people to offer themselves to any employer on any terms. So building on Reich's concern with dependence and domination by recognizing the power that property confers over private parties, casts his proposal to create an entitlement to welfare in a more expansive light. Welfare benefits that are generous and unconditional, as Cloward and Pivens recognize, provides both recipients and laborers with a viable alternative to paid employment when private employers fail to offer a better deal. If access to a reliable source of income, whether new property or old, safeguarding individual freedom provides a reason both to provide that income and to structure delivery mechanisms in ways that do not merely substitute state domination for the domination of the private employer. So focusing on the state's protective obligations, I think, has implications for questions about both access to civil justice and to economic inequality. Access to non-criminal enforcement is crucial to the use and enjoyment of property, and yet in most cases libertarians seem unperturbed that it's available only to those owners who are willing and able to pay for it under our system. Certainly this is contingent, right? But the way we fund civil law enforcement in this country leaves the cost primarily on the rights holders. If the anticipated cost of litigation to vindicate private property rights is high, then it may not be feasible for owners of private property to go to court to get their rights enforced. And when they're confronted, this is true even when they're confronted with a clear violation of those rights. As Gideon Parchamovsky and Alex Stein have correctly argued, this in turn, people can look at that situation and identify it in advance. It will encourage the prospective rights violator to go ahead and violate the owner's rights. And we would expect to see more of this kind of predatory self-help in situations involving poor property owners. And property is pervasive, right? So very poor people have property rights. I mean, if you're a tenant, you have property rights, right? The landlord-tenant rights are property rights. So I'm using property here broadly, not meaning just landowners, but any kind of property entitlement. And we have, in fact, seen a good bit of such systematic abuse. One example is in the recent foreclosure crisis. I'll talk about robo-signing in a moment, but an even more egregious example, if that's possible, comes from bank property managers. Numbers here are hard to come by, but according to a lawsuit filed by the state of Illinois, banks' property managers routinely invaded homes occupied by people going through foreclosure but not yet foreclosed, so property that they still own. In many cases, these managers removed, damaged, or destroyed personal property that was not subject to foreclosure, changed the locks on the home before foreclosure had occurred. They also cut off utilities without authorization and frequently attempted to intimidate people into leaving their properties even though they were legally entitled to stay. And I think this kind of brazen behavior, right, is fueled by the phenomenon that Parchamovsky and Stein point towards. It's important to acknowledge that there are some benefits from high expenses associated with formally enforcing property rights. Among these is a beneficial tendency to under-enforce property rights and to favor instead informal accommodations, and that in some ways is the topic that Sonia Katyal and I discussed in the Property Outlaws book that Chuck mentioned. But high litigation costs provide a kind of backstop, right, to these informal understandings. But under-enforcement or reliance on informal mechanisms like norms is most likely to be benign where, as between neighbors and other private individuals, the parties are relatively equally situated, where instead it's the result of wide asymmetries in the access to resources for civil law enforcement. Under-enforcement starts to look like abuse. So the robo-signing scandal, I think, provides another example. To date, none of the national property rights advocacy groups involved in eminent domain abuse or movements or anti-regulatory movements have called for reform of the foreclosure process or for punishment of banks who fraudulently foreclosed on the basis of false affidavits filed with courts asserting that paperwork was in order, and these were perhaps hundreds of thousands, if not millions, of homes that were foreclosed upon on the basis of fraudulent documentation, and not a peep from the property rights groups. The connection between access to justice and property insecurity suggests that some affirmative kinds of government support are necessary to empower the poor to defend their rights against private, non-criminal aggressors on a typical libertarian understanding of property rights. Now, as an alternative to subsidizing private law enforcement, the state might be justified, again, on property protective grounds in engaging in proactive regulatory efforts to prevent property violations from emerging in the first place. And I think viewed through this lens, at least some state regulation operates as a kind of analog, a sort of pragmatic alternative to criminal prohibition and punishment of certain harmful behavior that has negative impacts on private owners. We can view, I think, environmental regulation in particular, though certainly not all of it, as performing this kind of property protective function. And a good deal of land use law, building codes and housing codes, I think, fall into the same category. And my purpose isn't really to defend this in any particular regulation or even this idea in a thoroughgoing way. Instead, is to make the more general point that because of his focus on protecting owners against government, Reich didn't consider the challenge of enforcing property rights for those without access to the levers of private law enforcement, and neither do contemporary libertarians. Focusing on private property disputes also highlights the connection between economic inequality and property insecurity for the least well-off. And obviously, there are these sort of claims contested about correlations between high inequality and property crime itself, the incidence of property crime. I always set those to the side. As with access to justice, the argument about links between inequality and security from criminal violations extends really into the domain of civil property violations, as Mark Galanter has argued in his classic article on the subject. An important question about the obvious disadvantage that the have-nots, to use his phrase, face in private property litigation is whether increasing economic inequality makes the problem of unequal access to justice worse, or whether the large versus small player dynamic that he identifies is endemic to a system with any significant degree of inequality at all, or alternatively, whether it's sensitive to shifts in the overall degree of inequality over time. And there are reasons to think that it is responsive to that inequality, I think. Sort of tangentially, scholars studying land titling programs in the developing world have observed that granting the poorest land occupants formal title to their land does not always result in increases in the actual felt security of their tenure. And they've pointed to differential access to the legal system and to political influence as hindering the effectiveness of formal property rights for the poor. Both the market for legal talent and political influence have strongly positional dimensions that are highly responsive to economic inequality. So as one study concluded, land titles appear to provide a feeling of tenure security mainly to the wealthy landholders who take advantage of it. The foregoing suggests that in addition to benefiting from improved levels of access to property enforcement, property rights of the poor are also enhanced by reduced inequality. And obviously, this is a counterintuitive prescription from the point of view of traditional libertarian property theory, which is tended to oppose affirmative government assistance outside the domain of criminal law enforcement, but I think it's consonant with a broad commitment to libertarian account of the property protective function of the state.